Good morning, everyone. Thank you for joining us for the Does Me Too Include You Too seminar and webinar. Today we are hosting some attendees here in our Thompson Hine Cincinnati office, as well as many webinar participants online. My name is Eric Clark. I'm a partner in the Labor and Employment Group with Thompson Hine. This morning we're going to talk about sexual harassment in the workplace. We'll explore some of the steps your company can take to prevent or minimize sexual harassment and discrimination, and how to respond if such allegations do arise. Before we begin, we have some preliminary notes about the materials and technology. Today's program is being recorded and will be available on our website. Because we have both live and virtual guests, we ask our in-person attendees to avoid talking except when asking a question or answering the question, of course, or rustling papers and making other noises that might be picked up by the microphone. The microphone's up here, so it's pretty far away from you, but it's surprisingly receptive, so it does pick up a lot. Those of you who signed into the webinar will notice a question box on the side of your panel screen. Please submit your questions during the presentation anytime you want. We have somebody here who is manning the question box feedback, so Lindsay will be able to ask those questions live during the seminar, and we'll be able to respond to them, and feel free to ask as many questions as you want. We'll take as many questions as we can during the program, and anything we can't take, we'll save time at the end to cover anything we couldn't get to. Of course, those of you who are here in the conference room, just raise your hand anytime you want. I would like to introduce Lindsay Nichols. Lindsay's an associate in our Labor and Employment Practice Group. She'll be screening the questions and assisting me today, and we'll answer as many of your questions as possible. Anything we can't get to this morning, we'll be happy to follow up via email. And with that in mind, we will get to our topic. And it does Me Too include you too on sexual harassment front. So first, we know that, everywhere in the news today are stories that are coming out about sort of different types of sexual harassment in different workplaces. It is certainly the hottest topic in labor and employment law, and arguably one of the hottest topics in the world right now. But there's some basic assumptions I have for today. This is not geared to be sort of your basic anti-sexual harassment seminar. I am assuming you have a strong anti-harassment policy in place, perhaps written by Thompson Hine in an ideal world, but if not, I'm assuming you have somebody who wrote that policy, did a good job on it. We're not going to talk about your policy today. I'm assuming you want to prevent and eliminate harassment in your workplace. In other words, your policy is in the right place, but also your heart is in the right place while we're here today. Your goal is to stop these things happening in the workplace. The third thing is you don't want to retaliate against an employee who makes a good faith report of harassment. Whether that is an accurate report of harassment, maybe they're wrong in their assumption about whether something is harassment, but your idea is you do not want to retaliate against those folks who make a good faith report. And so you want to encourage those behaviors. You want to minimize liability and legal fees. I'm assuming if you're running a business, that's one of your primary goals. And then the last one is you do not know every single word that is said, typed, texted, or otherwise communicated between employees at your company. And look, this is basic, right? We don't know what people are saying on Facebook or on Twitter or what they're talking about at lunch, when they go out to lunch, at happy hour after the workday is over. We don't know everything that can happen. And so our concern is how do we figure out, how do we limit our liability? How do we do all of those other things that we talked about while still recognizing we can't be Big Brother and control everything that's said. So with that in mind, let me give a few words about the law. There are two general things that come up when you talk about discrimination or harassment in the workplace. And they're really two different things, discrimination or harassment. Discrimination is your conventional, hey, you're not getting promoted because you're a woman, or your pay is different because you're a woman, or that there's some differential treatment in the workplace based on your status in a protected class. Harassment is different. Harassment in and of itself has two different kinds. One is quid pro quo harassment, and the other one is hostile work environment harassment. So quid pro quo harassment, this for that harassment. The idea is in order to get something, I need to get something. And the example that we've probably seen much about in the news over the course of time is a movie producer who tells an actress, if you want this part, you have to do something for me. I feel a little slimy even saying that out loud while we're in the room, but that's the general idea of quid pro quo harassment. There's clearly an exchange of items that takes place. The other type of harassment that is sort of more common in terms of the number of claims we receive is severe and pervasive harassment or hostile work environment harassment. usually what this requires is more than a single stray comment, although sometimes even a single stray comment is enough. But the idea is that the harassment, the conversation, the communication, the involvement in the workplace is so severe and pervasive that it actually alters the terms and conditions of employment. Remember that Title VII, as it's written, just says that you cannot alter the terms and conditions of someone's employment based on their gender or sex. So it doesn't say anything about sexual harassment in Title VII. The requirement here, from the legal standpoint, is that the harassment then needs to be so severe and pervasive that it affects the terms and conditions of employment. An example of this is repeated requests for a romantic or sexual relationship from a coworker. But this is not the exclusive way it can come up. It can come up, for example, if every time a particular person works overtime, it happens that they're unable to avoid catcalling or whistling, or it could just be that they feel uncomfortable because certain people are creating an awkward environment for them. It could be every time they walk into a particular room, the room is coated with pictures of half-naked people or inappropriate things like that. Or it could simply be workplace banter that is not directed at them necessarily, but that is so pervasive that it makes them uncomfortable operating. Any questions about the sort of baseline definitions? Okay. So I said in the last slide, of course, that a single incident generally is not enough to lead to liability under the law. But the practical reality is, even a single incident can lead to a lawsuit or charge. And this is because people know that something's inappropriate. If someone makes a single comment that is inappropriate or improper, people who have read the news, read the media, think, hey, you can't do that, that's sexual harassment, and so they can file a charge. And even getting a charge, even receiving a charge or a lawsuit, unfortunately for you, can lead to attorney fees, it can lead to media coverage that you don't want to have in your workplace. So even if you win the lawsuit, it may still be a loss for the company. And some of the things that happen here as well could include just sort of problems with your employees. You don't want your employees to be unhappy, sort of the same thing we were talking about before, that even a single incident can be bad for you, and you really want to prevent those from happening. So what can we do to avoid even that first remark? All right, so let's be completely honest. There is no perfect panacea here, right? There's no way we can stop every employee from ever saying anything that is improper. But there are things we can do to make sure that most employees, most of the time, should not be making these remarks. The first one is training. We'll talk a little more depth about what kind of training, but training needs to be on a regular basis. It can't be a single time, hey, this is going on, we'll do training, and then we won't talk about it again for 30 years. For a lot of reasons, that's not a good idea. One of which is you might have new employees, but the second is training that I took 6 months ago sometimes isn't fresh in my mind. It isn't creating the culture we need. Never mind training that happened many years ago or when I first started the company. The second is creating a culture that does not tolerate or encourage such behavior. This is the hardest piece. And we'll talk about a couple of ideas about how to do that. But the last one is when something does happen. And in almost every organization of any size, at some point, something improper will happen. It is the way, unfortunately, the way that we live, something's going to happen. The best way to create a culture to prevent that first remark in the future is to do a prompt investigation, and at the end of that investigation, some kind of result needs to happen, whatever that is, whether that's talking to the person, whether that's closing it out with the person who stuck with the first remark, whatever that is, there needs to be an engagement in the process with that person at the end of the investigation. All right, let's talk about our training. There's really two types of training that I would encourage you to go through. The first one is your supervisor training, and the second one is your employee training. These are different trainings. You should not be doing the same training for your supervisors as you are for your employees. And the reason is supervisors have a broader responsibility in the law, but also in the very nature that they're supervisors. So the first one supervisors need to look at is issue spotting. They need to be aware of not just issues that are actual sexual harassment, but things that could be indicating that sexual harassment might happen. Under the law, if your supervisor knew or should have known about harassment between two coworkers, that is enough to impart liability on the company. If the supervisor didn't need to know, or wasn't aware, or had no reason to know, then liability really doesn't trigger to the company. So issue spotting, looking at issues, looking and seeing particular patterns, seeing that maybe a person is uncomfortable in particular situations, or avoid sitting next to someone at lunch tables or at meetings, whatever it is, are important issues to look for. So issue spotting is number is very important because when this issue happens, when an employee comes to one of their supervisors and says, hey, you know, I don't want you to tell anybody about this, but I felt a little comfortable with James lately. I don't really know exactly what it is, but something just isn't sitting right, and I'd appreciate not working on the next project with James. So your supervisor needs to know how to handle that because that's not a report of sexual harassment. Nothing specific has been alleged, and yet the supervisor needs to at least realize that something underlying is going on and how they should be handling that concern and what reaction you want from the supervisor under those circumstances. I can tell you that as a lawyer, the comment of please don't tell anyone this is one of the biggest tips for me to say you need to tell someone this. It's sort of the same way as when you train your kids about things. So how to handle those concerns and what their steps are very important. The supervisor needs to react to even subtle signs of things that are going on in the workplace. Investigation. Your supervisors need to be trained to conduct an investigation. There are times they will be involved in an investigation. There are times they will be the subject of investigation. They need to understand how to play both of those roles. Both roles are very important, and both roles are critical to be trained on. And of course, supervisors need to know how to behave. Not all of our people that we hire have great life skills training. You know, maybe their parents didn't raise them correctly or whatever it is, but they need to know what the behavioral expectations are for when they're in the workplace. How to treat their employees, how to treat their coworkers, and how to help foster an inclusive environment. Now, so that's the supervisor training. The second type of training is employee training. Excuse me. Employee training is just as important because this is where we will make sure employees know that we have a workplace that allows reporting, that there'll be no retaliation for reporting. Many employees, I mean, you know, all over the media, all of these stories, many of these stories would come out with employees who felt like their career would be over if they reported a particular issue. In our workplaces, that can't exist. That is, the failure to report is a huge issue from a liability standpoint, from my perspective, because if an employee says, I did not feel I was allowed to report, that suddenly eliminates that burden on the employee to prove that we knew or should have known and didn't react. Because one of the protections from liability that one of our affirmative defenses is that we investigated promptly or that we didn't know about it. If they can prove that they were scared of retaliation, there's no need to report it, and we can be liable even if there was no action on our part where we knew or should have known. So really, we should be encouraging reporting, and we want our employees to feel encouraged when they see something improper, even if it doesn't happen to them. If I see something happening to a coworker, to John or Larry or whoever, I need to be encouraged to report what I saw that was inappropriate behavior. And by the way, you know, much of the media coverage obviously deals with male to female harassment and things like that. The law is not limited to that kind of harassment. It can cover a wider range, including female to male sexual harassment. And the last one is, again, our employees need to know proper behavior. That is really key in any aspect, regardless of what level of they are in the organization. An appropriate behavior training is very important for all of our employees. Culture. So I said there were two types of training. Really, there are three types of training, but I moved the third type into this category of culture. And the reason is it deals with executive training. Your supervisors have one level of training they need to work with and how to deal with employees, how to lead employees, but the culture that we need to create to really prevent this from happening starts at the top. It is a leadership issue. It is executive training and making sure our executives own the plan. They own creating the culture that prohibits sexual harassment, that stops it from happening, and does not encourage it from happening at any level. So it is a leadership-driven issue. Again, repetition, I talked about it before, but the leaders need to own repetition from a culture perspective. It needs to be talked about on a regular basis. Certainly, in the first couple of years of something happening like this, we need to talk about this on a regular basis. Maybe every executive team meeting ends with a particular discussion about it, or some way of making sure avoidance of sexual harassment or inappropriate behavior is covered on a regular basis. There should be a zero tolerance policy for these types of behaviors. And that's important because because the law may say that a single stray remark is not enough to create liability, but that doesn't mean our policy has to say that. Our policy can say zero tolerance. A single stray remark is enough to get you fired or at least severely disciplined. Consistency. The messaging needs to be the same from every level. And this can include different managers. It is not good enough from a legal perspective or from a culture perspective where we say, oh, the CEO is very good and the COO is very good and the CIO is very good. The CFO doesn't get it, maybe he'll come around, but the problem is as soon as one leader falls in the chain, it seems like the entire organization has questions about how serious the leadership is. And so it needs to be consistent at every level in every organization that sexual harassment and prohibition of sexual harassment is a serious issue. Results. If someone violates the rules, it needs to take action. This comes back to our investigation issue, our prompt investigation. It doesn't matter who it is. It does not matter if it's your top salesperson or rainmaker or most important professional in the organization. If someone violates the rules, we need to take prompt, immediate action. It needs to be consistent across the board. And this is a difficult business decision because if it's someone who is very important to your organization, it is sometimes hard to take those actions, but it's critical that we do so. All right, any questions about those things? I want to talk to them about some of the state law issues and some of the other legal issues that are coming up. Okay. So there are many states that are reacting on a federal level as well. Many changes to the laws that are coming about. And what we have is New York, California, New Jersey, Pennsylvania, South Carolina, and Washington are all in various stages of looking at passing laws that limit the use of non-disclosure and mandatory arbitration clauses in employment contracts and settlement agreements. So what that means is you will not be able to use the non-disclosure agreement in these states when it comes up with particular types of action, sexual harassment, for example. That would be a massive swing. Every separation agreement that I have ever written includes a non-disclosure agreement, almost without fail. And that's important to us from a culture perspective of an employer. Hey, I am paying you X number of dollars. And I don't want anyone to know that because it's really sort of a nuisance value claim. Most of the claims that we sell are nuisance value claims. That's the reality of it. And I don't want people to know that all they need to do is file a lawsuit against me, and I'm going to pay them X number of dollars. So it's important to us to have these non-disclosure agreements. On the other side, you can see how being able to pay off a victim of sexual harassment prevents the issue from surfacing on a public policy issue. And so, there are certain companies that were able to keep a lot of this quiet for a long time because they would say, we'll give you $1 million to be quiet. And that is a significant public policy issue. There are a lot of arguments about it. There's no guarantee that they'll pass in any of these states. They could pass in all of these states. We'll definitely be keeping an eye on it. But as you can imagine, proponents argue that these types of clauses keep bad behavior out of the public eye and don't effectuate widespread change. So on the other hand, opponents are arguing that there's a compelling reason to keep some of this out of the public eye. Sometimes plaintiffs in sexual harassment cases are the ones that want me to keep it confidential because they don't want anyone to know what happened to them at the workplace. They don't want to know what went on. And so they are interested in keeping these things quiet. And so it really can cut both ways in terms of favoring or not favoring people. A few states as well, I talked earlier about how a single incident of stray comment, a thing that happened, is probably not enough to trigger liability, though sometimes it is. Florida and New York are both considering laws, have both had laws proposed that would actually make a single stray incident enough to constitute sexual harassment under those laws. That's an interesting law because it's sort of getting directly to a very minor piece of sexual harassment law. It would be interesting if those laws passed, but a single incident can be significant because these laws are not talking about a single supervisor making a comment. They're talking about a single coworker making the comment. And so depending on what your organization is, if you have people who work together, the numbers indicate that a significant number of relationships start in the workplace, and that would indicate that even a single time of someone not being interested in someone else's advance could potentially lead to one of these claims. That could be very difficult from an employer standpoint to manage. I'm not one who necessarily encourages, the relationship agreement from the office, as we've seen in a couple of TV shows, but you can see why some of these things would come to pass with some of these laws. Training requirements. So my hope is that no one on this call, no one in this room, no one that has ever talked to me about any of their labor employment issues ever needs to worry about these laws. And the reason is you should be training every year. And it should be prompt training, it should be effective training, all of your employees for all the reasons I just talked about. But if you needed an additional reason, several states have a requirement that you engage in such training on an annual basis. California, Connecticut, and Maine, I guess every 2 years. But it should be every year, it should be an annual training level. It's very important to set the culture that we talked about before. There are also some additional states that have talked about additional training requirements on this issue, and I would not be surprised if some of these training issues are passed, because the training requirements are an easy step for states to pass to react to sort of the ongoing Me Too issues. State initiatives to strengthen protections. This is just in New York. The New York Governor Cuomo has put forth sort of a 4-part plan to help combat some of these issues. One is mandatory annual reporting for companies that do business with the state of New York. So keep in mind, not in the state of New York, but with the state of New York, that they would have to disclose on an annual basis the number of sexual harassment adjudications and non-disclosure agreements that they have entered into during the past year. So that's a significant issue, because what they're saying is not that it's, you're not barred by having a single one of these agreements. They're not out and out prohibiting a single agreement. But they are saying, if you have 35 of these agreements every year and you only have about 200 employees, maybe something's a little off, and maybe we should look a little closer at what's going on there. So it actually creates a little bit of a reasonableness examination standpoint, provided, of course, that this isn't just a manual report that goes into a drawer somewhere and no one ever looks at. Additional legislation that talks about the prevention of the use of taxpayer money to fund the cost of sexual harassment settlements against public officials, which is significant. Look, let's face it, the movie industry is not the only place that we have seen a lot of reports of this. The political arena through Congress and other places has seen a shocking number of these types of allegations. The third one is banning use of confidentiality agreements in the public sphere relating to sexual assault or harassment, unless it's the express preference of the victim. That's a difficult one to enforce, because many times in settlement cases, the victim may be particularly interested in that if they get an extra $100,000, so it may be in their express interest. So that'll be a difficult one to enforce. And the last one is to create a uniform sexual harassment policy, sort of a uniform code that deals with these issues. That's an interesting one, because I'm not sure how effective a uniform code or policy would be. Every company in Ohio, every company across the country has mandatory postings that they put up every day or every year. And they're in particular places, and that's where these mandatory policies would go. And in some ways, they would go out of the places that employees are more likely to look on a regular basis, which might be their handbook, which might be in the training. And to the extent those go into sort of a uniform code, I'm not sure that it's really going to achieve the desired protection that we want. And certainly, there's no way that the uniform code could be any more effective than one of the policies that we draft that are specifically tailored to your industries. Equal pay act. So this is not generally a discussion today about discrimination, focused largely on harassment and some of the Me Too things that are going on, really the quid pro quo issue. But I always think it's important to remind people of the Equal Pay Act. So there is an Equal Pay Act in the federal government, but many states also have Equal Pay Acts. And as part of the Me Too movement, there's a lot of discussion again about the 70 cents on the dollar, or 77 cents on the dollar, 78 cents on the dollar, depending on your particular statistics. And the Equal Pay Act in each of these locations is really geared at preventing those types of numbers. The California's Fair Pay Act bars employers from paying workers of one sex more than workers of the opposite sex for substantially similar work, unless it can be justified by a factor other than sex. The important thing about this is it flips the burden. Generally speaking, in a discrimination case, for someone to show that they are being discriminated against, the person claiming that has the burden to show I'm paid less and there's no other reason to justify it. The California Act says, all I need to show is that I am paid less than my male colleague. I'm in the same role effectively. And that's enough for them to shift the burden to the employer. The employer must then prove that there is a factor other than sex that justifies those pay differentials. So in 2017, two big changes went into effect on that front. The Fair Pay Act was expanded to include the compensation differences between members of one race or ethnicity and those of another. So it's not simply a gender issue. And the second one is the Fair Pay Act now explicitly prohibits an employer from justifying an otherwise unlawful difference based on prior salary. In other words, past discrimination at a different employer, which may very well be the reason that someone left their past employer, is not a good reason to perpetuate that pay differential going forward. So that's what, those are the two big changes. And those are significant changes because, in particular the last one, and a lot of the Lilly Ledbetter cases that we had that went on for a while, if anyone remembers the Lilly Ledbetter Fair Pay Act, when that statute first came out, when those were first being litigated, the overwhelming reason it was given in a lot of cases, not one of the major reasons it was given in a lot of cases, was the person came in at this particular level and they got the exact same percentage raises every year. But the problem is when one person started lower than the other person, that pay differential perpetuated over an entire career, even though they had identical performance ratings, identical everything else, that the pay differential stayed the same, or actually grew if they got the same percentage increases. So now the historical entry into the workplace is not a valid reason. Any questions on those Equal Pay Act issues? Okay. Tax law. The tax laws were changed. I'm sure that your businesses are all scrambling to address various issues with the new tax laws. But the other one I want to draw your attention to is that you can no longer deduct the settlement costs or attorney's fees associated with claims relating to sexual harassment or sexual abuse if the agreement contains a confidentiality provision. This is a federal issue. So that means if someone alleges sexual harassment and you hire Thompson Hine, as you probably should, to defend any of those claims, you can't deduct those fees if you have a settlement agreement ultimately that says you're going to keep the settlement agreement confidential. In addition, you can't deduct the settlement cost itself, even though you may be paying his wages, right, as a 1099. Those historically have all been deductible expenses that you have taken out. That is a difficult change, and it's one that sort of requires at least a thought about how you're going to deal with that. And maybe on its own, that's not a major issue because you're talking about relatively small dollars most of the time. But there are significant issues in how these cases will be settled going forward because there are open issues associated with how you allocate the damages. Are we going to break apart particular portions that deal with sexual harassment claims versus non-sexual harassment claims? So if someone brings an age, gender, and race claim, are we going to be apportioning less of that money to the gender claim? In addition, the attorney's fees for the plaintiff. There is no differential in the way the law is written that would say that plaintiff's attorney's fees are deductible. Historically, employees do not need to report their own attorney's fees as income. Now, if we want a confidentiality provision in the agreement, arguably, the employees need to report not only what they get, but all of what their attorney gets as income, which can completely eviscerate the value of the settlement because they have to be taxed on the attorney's fees. Those all of that benefit to them goes away, as well as to the applicability to the general waiver and release of claims in the context of a severance agreement. Look, every agreement I write, when you're letting someone go, you negotiate an agreement. It happens all the time. Hey, look, it's not working out. We want to give you a soft landing. But of course, as part of that soft landing, we want you to waive all of your claims against the company. Here's an agreement. Part of what's in that agreement is a waiver of all claims, including sexual harassment claims. And it's not that we think there's a claim that's out there, but we don't want one to pop up down the road. So the question is, does this rule apply to those types of claims? What if you're paying someone 6 months of wages or 3 months of wages? Does that mean you can no longer write off those expenses? As the law is currently written, it probably applies to all of those things. It is broad enough in its language to prohibit a deduction on all of those. It has not been tested yet. No one has looked into it. No one has, we don't have any guidance from the IRS one way or the other, but as it's written, it's arguably broad enough to pick up all of those payments. Any questions about that? I hope not too many because I'm not a tax lawyer, just enough to know that I should be highlighting this issue for you. Okay. Let's talk about a couple of hypotheticals. The first one, we have a female salesperson reports that a large customer is sexually harassing her. Which of the following is true? A, we cannot control customer behavior, so legally it's safe for us to ignore the problem. B, we should transfer a different salesperson to the account to stop the harassment. C, we should investigate the allegation, determine what is happening. Or D, B, and C. I loved your answer. Yeah, thank you. The answer is C for those on the phone. So first, any behavior that affects our employees is our responsibility. It does not matter who is creating it. If their workplace is being impacted by it, that is under our control. And even if it is our largest customer, even if it is our only customer, and it is the owner of our largest customer that is doing it, that is our responsibility to fix. Those aren't always easy things to deal with, but they're things we need to deal with as employers. So any behavior that affects our employees' terms and conditions is our responsibility. B, transferring the person to another account. This is not an acceptable approach, especially in a sales commission-driven environment. You can't just simply transfer the person off the account. Now, it is possible that the person has requested to be transferred off. They want to be moved to a different account, but even at their request, there are particular pitfalls you have to deal with. For instance, moving them to an account that is less profitable may still create compensation issues that we need to deal with, and how to deal with it going forward, even if you are successful at managing the client's expectations and what they're allowed to do and not allowed to do, and you have an agreement with the client or customer about what they're supposed to do, moving that person off of that account can be difficult and can create issues going forward and whether that person wants to continue to work with them. Yeah, sure.
So then what happens if you don't have the customer agreement going forward? You have no control over that customer. You have control over what you can do in terms of future dealings with that customer. But to what extent do we have to take steps in that kind of situation other than potentially transferring the sales?
I mean, arguably, you have to do whatever you can, whatever is possible, to make sure that that person is not suffering from the harassing environment. And I'll tell you that every situation is a little bit different. It could be that in some circumstances I've dealt with this issue in a few cases. One time I went to this sort of the effectively senior person at the company and said, you need to assign a different person for this relationship. And they generally agreed to that. Normally, if you go high enough up the chain and explain what the issues are, they will take very promptly to the customer. Yeah. And so I've done that before. Sometimes you contact their general counsel, depending on how their structure is. You can usually find someone high enough up that understands that what's going on is inappropriate. But the first step in that is going to be the investigation. Because what you do not want to do is get a report that something inappropriate is happening, and then immediately go off to the customer and say, hey, my employee says it's terrible, you need to change who's on this account. What you need to do is sit down and talk to that person, ask if there are any other witnesses, understand what the allegations are, and then make an informed approach to your customer and say, this is what we've seen, this is what's going on, we'd like to talk to your employee about it and understand that particular person's side of the story, and potentially, once you've uncovered that, make your own determination about what happened, and then go back to them with some potential solutions. But usually it requires working together with the customer to find an appropriate way of dealing with the situation.
Oh, question.
Yeah, absolutely.
So what happens, as in a lot of cases with employment claims, there's a he said, she said, completely inconclusive, wildly different, disparate positions. What do you suggest in that situation?
So I think it's important for you as the employer to do your own investigation and come to your own conclusions. And if you believe your employee and that he said, she said worked out that the other company believes their employee, then I think you need to go to the employee, it's your employee, and talk about what the appropriate resolution is. And often they have a very specific thing they want to happen. It's not always easy, and I think that you have to crack the situation. There are employees who will say, I don't want to work on that customer ever again. And And so maybe you have to find an appropriate replacement for that customer, move them to a different customer if that's what they want, which is okay as long as it's reasonable compensation difference or reasonable compensation comparison. It could be that they say, you need to drop the customer. I don't ever want to work with them again. I'll find a new customer. That may be the only option. Not a great option, I realize, from a business perspective. Or it could be that the person says, I want to keep working with them. I just wanted to put them on notice, so I'm willing to continue doing it. You might want to assign sort of a coach to go with them or a coworker to go with them to protect particular issues. And again, every circumstance is very different. You could also say to them, hey, look, it seems like these are happening in these particular locations. So I know that often our situation involves going out to dinner, going to drinks with that person. Cut that part out of your job. Your job now is dealing with them only over the phone or only when another person is in the room. So again, I think you need to be creative in tailoring the solution to that problem, to the situation, in a way that doesn't hurt the employee. And it could be, I have found circumstances before where their concern is legitimate in that they don't like something someone said. On the other hand, it's probably not harassment under the law. And so the other company feels like it's not as serious. And then you have some decisions to make there as well about how you react to that. Any other questions on that? Okay. So the investigation, again, hugely important. It is the most important thing. And frankly, in every single case, the most important thing we do is the investigation. It needs to be thorough and it needs to be prompt. Every single person is busy. I understand that. We all have jobs, and the primary focus of our job is almost certainly not investigation every single day. And yet, it needs to be the most important thing you're doing during those times. If you get a claim on Monday and you assign the person to work on that case to investigate it on Tuesday, and that person says, okay, I'll get right on it, and they reach out to the person to schedule the first interview on Thursday, and then they don't schedule the interview until next Wednesday. What has happened is a week and a half more of harassment has gone on during that time. And to anyone else, and then they do the interview on Wednesday, and they get other witnesses, and they schedule those for the following week, and then ultimately they have 14 witnesses that they deal with over the next 3 weeks, and then it takes them a long time to summarize those into a report, and it takes 2 months until the report's published. Unacceptable. I know that that is hard. I know that's difficult to hear, but even a little delay in an investigation is too long. And so the investigation needs to happen in as short a time as possible, ideally within days. All right, next typo. John is a male employee. He reports to his supervisor that he's uncomfortable working with Mike, who is another male employee, because Mike regularly tells John about his various sexual partners. None of the sexual partners are employees. A, this is not a problem because it's just typical male banter. B, this is not unlawful because neither Mike nor John is a supervisor. C, this is not unlawful because all the sexual activity took place outside of the office. Or D, none of the above.
D.
Thank you. You're just on top of these today. Thank you. That's great. And they're a little bit easy, but each one prompts particular conversations that are important to have. So the first one is typical male banter is a phrase that should never be used in the workplace. There's no such thing as typical male banter because first of all, it creates an assumption that women would have the same banter, which is probably an inappropriate assumption. And second of all, it's often used as a sort of code word for that's okay in a boy's world, and that is not an appropriate approach to take under the sexual harassment laws or in today's culture. The key issue here is that this person's, John's, conditions are affected, his terms and conditions of employment are affected by the harassment, and it's based on gender or sex. So it doesn't matter that it's not his particular gender that issue in the discussion. He is uncomfortable because his workplace is permeated with discussions of a sexual nature. And that's not something that anyone has to deal with, should have to deal with every day at work, because it's affecting his ability to work every day. And he's uncomfortable. He's saying, I'm uncomfortable working with Mike. He's tired of hearing about this all the time, and it's making me feel uncomfortable. And it could make him feel uncomfortable for a variety of reasons. But it doesn't really matter what his reasons are if he's he's uncomfortable, it's inappropriate. Now, the interesting thing is, if only those two work together in a room, no one else can ever hear them, a different question is whether it's still inappropriate if they're having those conversations in a completely closed room. First of all, it's probably not illegal. It is not creating a legal liability for you for two people to have sexual conversations where it's not affecting anyone else's workplace, as long as neither one finds it to be unwelcome. That said, if you are aware this is going on, it creates probably a risk for you, and I would probably encourage you to tell your supervisors they should make sure those employees are cutting that out, that they should not be doing that in the workplace. Because in this situation, maybe it was okay at first, but then it grew to such a point that it's no longer comfortable, which you can see as a common fact pattern that, by the way, arises in a male-female relationship. Is one of the more common sexual harassment patterns we see, which was there's a little banter, a little flirtation that goes on between a male and a female employee, and then one of the employees grows that to a point where the other person no longer feels comfortable with it. And that happens on a regular basis, and that creates some of the liability. And of course, the employee who escalated the flirting would say, well, no, that the other person's okay with it. But they weren't okay with it at a point, and it becomes an uncomfortable situation. So my recommendation to you is if you see this type of behavior going on, what I would say is this is not appropriate in our workplace. I realize that no one is upset about it. I realize nothing's going on, but still, you should take these conversations out of the workplace.
I have a question.
Yeah.
So does the degree of the discussion have any bearing on this? For example, it's just name, and that's it.
Yeah. Well, again, it's all context, right? These are all fact intensive. So if the person comes in every Monday and says, "Hey, went on a date last weekend with blah blah blah," probably not appropriate. That's normal. That would be normal workplace banter, not male banter. Workplace banter, very different conversation. Normal workplace conversation, especially someone you work with every day. You may get to know them pretty well, understand who they're dating. Maybe that's significant. Probably not inappropriate. On the other hand, if they come in and say, "Hey, 3 Tinder activities last weekend, really exciting weekend, Susie, Jane, and John," maybe that's a little more difficult for someone to put up with every single weekend when they're, even if they're just saying names, if there's enough of an inference to sort of create the uncomfortableness in there. So I think we, it would vary on the circumstances. But it's certainly possible that what one person would not find offensive, another person would. And so we need to be cognizant of that issue. And the hard part about this is if John reports this, and John and Mike may be friends, and it may just, they're work friends. But it may just be that John has been reluctant to report this because he doesn't want to create a bad relationship with Mike. But that's what very much could happen. Mike's feelings could be hurt because he thought John was his friend and he enjoyed talking about these things with him. Our job as an employer is to make sure that no retaliation comes out of that. If the workplace doesn't become icy because of that, it's still a good workplace. But what's really important in an ideal world is that we've created the culture in advance such that we can easily explain to Mike, you had this training. You know that we're not supposed to be doing these things. This is not something you should be saying in the office under any circumstances. So you really need to cool it down. And it should be done in a way that probably isn't singling John out as, hey, John says he can't work with you anymore because all you do is come in here and talk about your various sexual partners. So it's the reaction to the situation and the dealing with the situation are very important. And also fact specific, yeah.
Is John under any obligation to tell Mike to knock it off?
It's a good question. Probably not on its own when it's so pervasive. The way that I phrase this is because all he does is come in and talk about his sexual partners on a regular basis. He could, and that would certainly be better from our standpoint, that, hey, you need to cut it out. But on its own, he probably is not required to because it happens so often. The courts probably would not require that. I would argue, by the way, if I was defending you, that yes, he absolutely does have to say that. But not every court agrees with me. Yeah.
What about rumors of romantic relationships? Mm-hmm. So you have employees that are just talking, they're passing time, kind of like they're back in high school. People are just talking, having personal discussions about rumors and stuff like that. Can
could if it's severe enough. You know, I mean, if you're saying, you know, again, it will depend on the fact pattern. Or, you know, if someone is saying, hey, I understand that Ed is dating an outside person, it's X, name outside person, probably not going to create sexual, you know, unlawful harassment. On the other hand, if there are rumors that, I'm not going to use your name this time, you know, if there are rumors that Mike, in this case, that Mike is quite the ladies' man, and he is out, you know, every weekend, you know, with two or three different women, and you know, the discussions could very quickly escalate into something that would arguably be inappropriate as the discussions grow and the rumors grow. You know, it's probably okay to say, hey, this person has a new girlfriend, isn't that really interesting? Or this person has a new boyfriend, isn't that really interesting? Probably not inappropriate. It's probably not appropriate to go much deeper than that in the conversation. And again, it's all an issue of how welcome it is and how unwelcome it is. Two people sitting around at the lunch table having a conversation is one thing when it's a mild conversation about a rumor or something they've heard. When it's repeated, when it's every day, that's all they talk about, you can see how that would become more difficult to deal with. Yeah.
We've got a couple questions from online, and Darren has asked you to repeat them into microphone.
Will do.
For the webinar participants. So the first one is it problematic for a company to host a self-defense class at work that includes close physical contact between employees and managers, even if the participants are there voluntarily?
Well, that's an interesting question. I did not see that one coming. So again, in case anyone didn't hear that, is it appropriate for a company to host a voluntary self-defense class that could involve close contact between supervisors and employees, because it's a self-defense class? Is it appropriate to host those even if the employees are there voluntarily? I think the answer to that question in my mind would be yes, it's okay to offer that class to your employees. If employees want to take that class, they're free to show up or not show up. I do think it's probably in the best interest of whoever's training that class to avoid creating awkward situations. But I don't think, assuming everyone's there voluntarily and doesn't have any specific objection to who they're partnered up with for the self-defense class, I don't think there's anything wrong with offering that class.
We had one other one, and this is just again for the.
Yeah, before we jump to that, I do want to say, you know, there are ways that could be an inappropriate thing to do. For example, if a supervisor who happens to be a little handsy happens to be the one that schedules those classes and sort of says, oh yeah, it's voluntary, but it's not really voluntary, and then he happens to pair himself up with a particular person that he's been difficult with, that's probably less appropriate. Or the activity that happens in that class could be inappropriate even if the class itself is appropriate. So I can see many pitfalls with it, but nothing illegal in and of itself. Sorry.
Okay. Oh, and then the next question was just for the webinar participants, are we making the PowerPoint deck available?
The entire presentation will be available, which includes this, and they'll be able to go through on our webpage.
Okay.
Excellent. All right, so last couple of points on here. Non-supervisors can create harassment, but there is a requirement that supervisors know or should have known of harassment. And then, by the way, the conduct that is at issue here is Mike telling the story. So even though nothing happened in the workplace with his various sexual partners, his conduct of telling stories is enough. And by the way, it doesn't matter if they're true stories or not. You know, it is enough that he's telling these stories in the workplace. That is enough to create a hostile work environment, whether it's man or woman or anyone else who he's saying that to. Okay. All right. And that's what we have. Any other questions? Anything that you want to talk about? I think we have 5 or so minutes before the end, 5 or 10 minutes before this officially scheduled end. Yeah.
What about social media harassment at work?
Yeah. So things that happen outside of the office that have an impact on the office can still be something that is a violation of your policy and can still be something you can deal with. So
we can deal with it.
You can and should. Because even if someone is only doing, for the sake of discussion, we have John and Mike. If John is dealing with Mike, or Mike is, you know, every day on Facebook with John, you know, stalking him or making inappropriate comments to him, then that can still create an lawful workplace harassment in the workplace, because when John goes to work every day, he feels like Mike is always there. And you remember, it's exactly what Mike was saying 2 hours ago on Facebook, what the inappropriate comments were, what the inappropriate issues were. You can see that in a male-female relationship or either way. And again, I know it's important to repeat, but that can go male-female or female-male as well.
Now, actions that occur outside the workplace can come back.
They can.
Into the workplace.
They can.
Not just on social media, I'm just saying you had a casual outing at the bar, completely not company-sponsored event, company-related event.
They can. If you know, the issue is whether the things that happen outside of the workplace create a severe and pervasive environment in the workplace. So the easy scenario to come up with is John and Jane are at the bar, and you know, the happy hour after work, 10 people with happy hour after work, and John has Jane sort of in a corner like, hey, you should really go out with me. I'm this guy, you need to know me better. And she's like, oh, I'm gonna go talk to my friends. No, stay here. We can talk about this more. And then she goes talk to her friends. Then he gets to her corner again later, and he doesn't let it go. And it happens, you know, 3 or 4 Thursdays in a row. And it gets to the point where Jane feels like every time she comes to work, she knows exactly what's lingering from what happened the day before, even if John never says anything in the workplace. But every time he sees her outside of the workplace, this is happening. It's affecting her work environment. Now, again, let me say that as a defense lawyer, I would be arguing very hard that is not, we had no reason to know, it's not our responsibility, but
they could leave each other, they don't have
could,
to be, because at the workplace, they're forced to be in this environment.
They don't have to go to happy hour.
They don't have to be in that public setting.
That is my argument.
I guess I'm missing the net.
Yeah, well, the issue is
that
the happy hour issue, going to happy hour is viewed as sort of a key component of the camaraderie building. And if what you're saying is, in order to avoid sexual harassment, Jane has to avoid all of the social activity anywhere that John might happen to be. That's probably taking her out of some of the opportunities for him. Now again,
but just by the mere happenstance of being employed at the same thing, I mean, this could happen completely devoid, not related to work.
It could.
Somehow.
Mm-hmm. So again, I think the fact pattern would be very, very important to how this develops. You know, is John a supervisor? Is Jane a supervisor? You know, who the situations are. But there is a way for the bar activity where it's sort of part of the, you know, everyone from the department goes every weekend. They create every Thursday night. That can create the hostile work environment issue because she has to go back to work Friday morning after having been repeatedly propositioned by him. And there's no way for Jane to say, oh, that bar activity, when I get back here, he's not like that at all, totally different person. She knows that he's this sort of over-pushy person who is going to repeatedly proposition her again and again, even if he never specifically does that in the workplace. So I would say it's a difficult case for Jane.
Just to carry that hypo further, if a supervisor is witnessing this happening, then all of a sudden now the supervisor is not on duty, not working, completely social, not related to work or company sponsored, now has an affirmative obligation to, because he knew or should have known,
to tell Mike to cut it out or John to cut it out. Probably so. I mean, again, very difficult case for Jane. I don't want to make it seem like these are slam dunks. They certainly are not. You know, part of what I'm saying is to be on the most safe side, that supervisor certainly should be telling John, well, she's clearly not interested. You need to back off. And this is not something that should be happening. And in those types of activities, that's probably right. By the way, it's much different if the two of them happen to be friends outside of the office, like friends of friends, and they end up seeing each other on a regular basis. That could be different than sort of a work, it's not, even though it's not a work-sponsored happy hour, everyone from the department goes. It could be different.
Well, let's take out that department.
Yeah.
It's not a department anymore.
Right.
They just happen to be a small town.
They happen to go to a bar.
There's one bar in town.
And they all go.
But it's not a department happy hour. It's not anything related to that.
Yeah. The issue is whether the activity at the bar is creating an environment at the workplace. And if it is, then the answer is yes, it can trigger liability. If it's not creating an issue at the workplace, then it doesn't create liability. Jane could not file a lawsuit, could not win a lawsuit anyway, for simply being subject to advances from another employee at the bar if it wasn't affecting the workplace. So let's talk about it this way. They work in totally different departments. Jane works here, John works on the other side of the building. They never even see each other in the workplace. But every time they go to the bar, John hits on her. Is that going to create liability? Probably not. But if they work in the same department, next to each other at the same desk, and every time they go to the bar together, John is hitting on her relentlessly. And by the way, a single approach of like, hey, I'm interested, you and I should go out, probably not going to trigger liability either. And even, a couple of months apart or whatever, not going to trigger liability. It's the relentlessness of it that then has an impact on the workplace is the issue. These are not easy questions, right? These are difficult questions to deal with, and because they are so tied up in sort of a basic aspect of human life, which is dating and whatever else comes from that.
I mean, I just see the employee response being, get out of my private life. This has nothing to do with you guys. I can see there's a fine line, I feel like, between, for example, if we hear about something happening in someone's household, like you have a spouse that works at the same company, but then we become aware of things that are happening in that household that affect their environment of work, and they're like, butt out. This is our personal business.
Yeah, a good example. I mean, I've seen circumstances where a sort of a domestic abuse issue comes into the workplace, and there are times where not that you're necessarily obligated to step into a domestic abuse case, but we might want to for a variety of reasons. And I mean, I've had clients who do that, and one of the things they want to do is sort of make sure they're not overstepping their bounds, as you've said. And you're right. Sometimes employees will say, "Get out of my private life. I don't care." But if the person who is saying that is the one that is creating a hostile work environment, yeah. It doesn't really do me any good. But anyway, look, these are, and you said it's a fine line, and I would actually say it's a gray area. Yeah. These are very difficult issues, and they can turn on one or two small little details. And again, what I'm sort of suggesting is, how are we trying to prevent being, part of this issue, part of the Me Too issue? How are you preventing your companies from being involved in that? And my recommendation to you is creating a culture where even the appearance of impropriety is unacceptable, and where you're encouraging the reporting in such a way by creating this culture that if somebody comes to one of your supervisor knows how to react, stop these things. All right, any other questions? Great, well, thank you very much, everyone, for coming, and we are all done.
Thank you.
Thank you.